Hello, everyone. Welcome back to the podcast. Today, we're starting a two-part deep dive into something that every sanctions compliance professional, every commodities trader, and every general counsel and chief compliance officer advising clients on energy transactions needs to understand right now. OFAC has issued a series of new general licenses under the Venezuela sanctions regulations that represent the most significant expansion of authorized Venezuela-related activity in years. So I'm talking about General License 52, General License 46B, General License 51B, which became effective June 10th, 2026, and the broader framework created around them, including the Foreign Government Deposit Fund established under Executive Order 14373. This new general license framework and this new payment mechanism are critical. And I want to be clear that these general licenses are not a sanctions lift. Venezuela is not off the sanctions lift. PDVSA remains a blocked person. The government of Venezuela remains a blocked counterparty. What these authorizations create are conditional pathways, specific, narrowly defined, procedurally intensive pathways through which certain otherwise prohibited transactions can go forward. If you treat these general licenses as a green light without understanding the conditions, you're not complying with the authorization. You're operating outside it. And the enforcement consequences for unauthorized transactions involving the government of Venezuela and PDVSA are severe. So let's go through the legal foundation first, and then we're going to work through the key authorizations. The Venezuela sanctions block all property and interests in the property of the government of Venezuela that are within the United States or within the possession or control of U.S. persons. Under OFAC's 50% rule, this extends to entities owned directly or indirectly 50% or more by the government of Venezuela, which means PDVSA and an extensive network of its subsidiaries and affiliated entities that are all blocked persons. Absent authorization, U.S. persons are broadly prohibited from engaging in transactions or dealings with any of these entities or their property interests. In early 2026, the United States adopted a revised approach, creating defined authorization pathways for certain Venezuela-related energy and mineral transactions while preserving the underlying blocking regime. The approach is elegant in concept, but the operational requirements embedded in these authorizations are demanding, and they impose obligations that most compliance programs are not set up to handle. So let me walk you through the three key authorizations that I mentioned. First, General License 52. This is the broadest authorization currently available. It permits established U.S. entities to engage in transactions involving PDVSA and PDVSA-owned entities that would otherwise be prohibited. And the authorization further extends to transactions involving the government of Venezuela itself that are necessary to conduct the authorized activities. So this is wide in its coverage, but the conditions are the story. An established U.S. entity means an entity organized under the laws of the United States or any jurisdiction within the U.S. on or before January 29, 2025. Formation date matters. If your company was incorporated after that date, General License 52 is not available to you. The contractual conditions under General License 52 are mandatory. They're not recommended. Any contract with PDVSA, PDVSA-owned entities, or the government of Venezuela must be governed by the laws of the United States or a U.S. jurisdiction, and dispute resolution must occur within the United States, period. If your template contracts contemplate foreign governing law or non-U.S. arbitration, you must modify them. There's no way around this. The jurisdictional restrictions under GL52 are also significant. It does not permit transactions involving persons located in, organized under the laws of, or operating through joint ventures with Russia, Iran, Cuba, or North Korea. And it also excludes transactions involving entities in Venezuela or the United States that are owned or controlled by or operating through joint ventures with persons from China. These exclusions are important, and they're triggered by ownership and control structures, and it means standard sanction screening is just not enough. And then there's the payment question, and this is the big issue which everybody is focused on, and that brings us to the Foreign Government Deposit Fund. Under GL52 and under GL46B, which we'll talk about later, monetary payments to blocked Venezuelan governmental counterparties generally cannot be remitted directly to PDVSA or the government of Arizona, meaning money to pay will not go directly to PDVSA or the government of Venezuela. Instead, those payments must be deposited into the Foreign Government Deposit Fund established under Executive Order 1373, or another account specifically designated by the Treasury. So let me say this again, because this is the most significant feature of the entire framework. You cannot wire a payment directly to PDVSA. You route the payment to a U.S. government designated account. OFAC has created a payment mechanism through which blocked parties receive value, but through a U.S. government intermediary, not through direct commercial transfer. The practical mechanics of the FGDF, Foreign Government Deposit Fund, work like this. Companies seeking to make a deposit must contact depositor inquiries, all one word, at state.gov. That's the email address for payment inquiries. And be prepared to provide extensive information about the underlying transaction. We're talking about the full legal names and addresses of all contract parties, a description of the underlying contract and the purpose of the payment, product type and quantities, copies of invoices, contracts, and reference identifiers, the total payment amount, currency, and proposed payment date, identification of the applicable general license, and contact information for follow-up. Only after the submission process is complete and payment instructions have been received can funds be transmitted, and to the designated government account, not to PDVSA. The compliance implications are enormous. Companies cannot treat Venezuela-related payments as ordinary commercial wire transfers. Every payment to a blocked Venezuela government counterparty requires prepayment legal and compliance review, documentation assembly, contact with U.S. government authorities, receipt of payment instructions, and verification before transmission. Transaction timelines negotiated commercially must account for this additional administrative process, committing to payment deadlines that assume ordinary commercial wire transfer mechanics is a recipe for contractual default and sanctions exposure. Now, let me turn to General License 46B and the newly effective General License 51B. General License 46B authorizes a broad range of activities involving Venezuelan origin oil and petrochemical products, which is quite broad, involving purchasing, marketing, transportation, storage, delivery, and related commercial activities. Again, only for established U.S. entities, same conditions, U.S. governing law, dispute resolution in the U.S., and jurisdictional exclusion for certain countries, and the same payment framework. Now, General License 51B, effective June 10th, 2026, supersedes and replaces General License 51A and extends equivalent authorization to Venezuelan origin minerals, including gold, exportation, re-exportation, sale, resale, supply, storage, purchase, delivery, and transportation of Venezuelan origin minerals are authorized for established U.S. entities under this license, but with important additional restrictions. The license expressly excludes exploration, development, mining, extraction, and production in Venezuela. It excludes formation of joint ventures in Venezuela for those purposes, and it prohibits processing or refining Venezuelan minerals in Russia, Iran, Cuba, North Korea, or China. It also imposes, General License 51B also imposes its own reporting obligation. Any person conducting these transactions must report to sanctions_inbox at state.gov and OFAC_intake at DOI.gov within 10 days of the first transaction and every 30 days thereafter while such transactions are ongoing. The reporting obligations and the equivalent obligation under the general license to report to state and energy are not administrative formalities. They are substantive compliance requirements. So that's the legal framework and the key authorizations. In the next part, we're going to talk about compliance program realities to execute within this framework. Thanks for listening, and I'll talk to you next time.